Good Saturday morning to everybody, and welcome to Legal Notes with attorneys Ned Barron and Mary Ann Sharon. I am Gary Byron. Good morning, gang. How you doing?
Good morning.
As I learned last week, by the way, interestingly enough, from last week. Well, actually, we got a question from them from our email, in our mailbag. I got to get to, as well as a whole host of other questions that pertain to the topic of this week. I learned, seriously, that you can't just write something down, mail it to yourself, not open it when you receive it, and have that be law. In other words, I write down where I've only got X amount of belongings. My record albums go to my dad or my son, or all my culinary instruments go to my sister. And no, you have to have this done legally here in the state of Connecticut. As you called it, a holographic will. That's not
called a holographic will.
Right. I remember that. You cannot. That does not get recognized by the state of Connecticut. So
Right.
Okay. Before I go to today's topic, by the way, happens to be second marriages. Oh boy, this is going to be interesting. I want to go to the mailbag, and folks, if you've got a question that you would like to have answered, it could be on these very airwaves even next week. The email address is very simple. It is legalnotes@charteroaklaw.com. All right, Cindy in Middletown, she writes, I was listening to the show. What happens when your life changes after you've written a legal will? Can you revisit the will to make changes? Or what happens if you forget to? Ooh, well, that's a loaded question right there. That's tough. But I would imagine is it more common than meets the eye?
It's not uncommon, but it definitely happens. Divorce is a great example where married couple, they create wills and then they get divorced and they don't change their wills. And most when you have married couples, typically it says, I leave everything to my spouse. In Connecticut, once there's a divorce, that the provision in the will leaving assets to that now divorced spouse is now voided. So that is not that provision is no longer in effect. So that's a good thing, but it doesn't address.
And if you owned joint property, as in survivorship, the divorce will disjoint the survivorship. So we have law that does some type of protection. But, life changes all the time to people. Sickness, illness, children, divorce is clearly one of them. And sometimes you do need to change the will to reflect that. We try really hard in our documents. So, for example, if someone comes to us and they have 2 children, and then our documents will address any children, even afterborn children. But we have seen wills where that's not the case. And so, someone dies and the first 2 children get something and then the third child is out of the will because it was never included. So we try really hard to create a document that can handle a lot of circumstances. So the document has some legs to it, but it just depends on, in this woman's case, we haven't seen her document. I have no idea if it's really like to the letter, so if it addresses those circumstances or not. And if you don't, well, if you never change the will, then I don't know. I guess it just depends on like how bad the event that occurred in her life.
Well, no, and she doesn't, Cindy from Middletown doesn't go into any specifics here, but she could have just been speaking very generally. But I'm thinking if somebody has a will made with their children, their spouse, their children, and let's say a divorce occurs, like you were suggesting, and then a person gets remarried and has another child.
Yes.
And if they don't update their previous will, well, number one, things are going to go to their ex, but also significant is that this poor new child gets left out of their parents' will. So if your life, I would imagine the more your life changes, and I mean significantly changes, the more updates that you would have. Would you just have a whole new will made, or do you make amendments or addendums to existing wills?
Well, an addendum to a will is called a codicil.
Okay.
And, my feeling is that those were done a lot more often in the olden days, so to speak, when we didn't have computers and word processing and all that, which because back then to have where everything had to be typed out by a typist, that took a lot of time, took a lot of expense to create a will. So then to create a codicil to that will made sense because it was usually a 1 or 2 page document amending the will that you had already signed. However, one of the downsides to that is that if that codicil is lost,
Right.
then now you have 2 pieces of paper, 2 documents to keep track of as opposed to 1. Now with word processing, that we're not worrying about the cost of a secretary having to type out multiple copies and the time it was going to take to do that. We just make the changes and have clients sign a brand new will. It's a lot cleaner that way. You don't have to worry about one document, and it's just it's more cost effective, I think, to do it.
Yeah, I mean, we've had circumstances where people have found the codicil but not the original will.
Oh boy!
And it's like, oh, what was the rest of it? So those they all involve their own complicating factors. That's a complication. And
we have heard cases where there are the codicil said, "I'm cutting out
yes
the bad child," and the bad child finds the codicil before anyone else does after the death
and rips it up.
Right,
it's gone,
destroys it, and it's gone. Right.
But how do you prove that? If it's gone, it's gone.
Well,
sometimes it's copies, right? So now it's pretty easy. We maintain a copy, and so if we know that it existed, the problem is that there's a legal presumption that if we can't find an original of a will or the codicil to the will, the legal presumption is that it was intentionally destroyed. So maybe the father,
by the person who signed it,
right, by the person who signed it, but maybe the mother or father thought better about it and said, you know what, at this point in my life, I had a lot of anger and resentment toward this adult child of mine, but I'm older and wiser, and I can't write the kid out anymore. And so maybe they did destroy it.
But destroying it doesn't nullify it. They would still have to get back in contact with you because you retain a copy of that as well. And as far as you're concerned, that codicil is still relevant.
You bring up a good point, because it would be nice if they got in touch with us to say, Marianne, just so you know, I decided not to. I don't want the codicil anymore, right? So when that person dies, the family comes, they open up the estate, and I'll be like, wait a minute, there was a codicil. Not that Ned or I are trying to create family drama, but if we know that something existed and it's not presented, so it would be nice if they did let us know, and we could just put a note in the file and say, we had this phone conversation, and I always tell people, I'm not going to destroy it. You destroy it. Right? You destroy your own documents. You shred it. We don't shred any of someone's original documents in our office.
No, but you have the copy there, though.
Well, we have the copy.
You can't destroy it unless you receive word. There's probably documentation that they need to submit to you to.
But we have all those type of things that can be complicating. Yeah, it's not easy.
Great question, Cindy. Appreciate the
Cindy, who didn't want to tell us what.
Well, no, I mean,
because sometimes she probably has
maybe
a good. That's exactly right. Yeah. That's exactly right.
Well, I think kind of to recap that question is just that if there is a significant life change, that is a good time to review with your estate planning attorney whether or not you should change your will, and those could be, death of a spouse or marriage. Or
illness.
Yeah. Well, yeah. Or if you have a new child, or if you have a child that predeceases you.
Oh yeah.
Those are all life events. Another example also would be is that you could draft have a will, sign a will, based on what your present financial circumstances are. But if down the road your financial circumstances change just dramatically, such as you receive a very substantial inheritance, that would be another life change where you would want to talk to your estate planning attorney to say, hey, when we first did this will, this is what our net worth was. Now it's this. Is there anything else that we need to do?
Well, that could pose trickle down effects, meaning that, let's say I received an inheritance, or it doesn't even have to be me or you or anybody in this room. It could just be, let's say there's an individual who receives an inheritance from a recently deceased parent. And I don't know, $500,000, $500,000. And this person himself ends up, remember, it's coming from his parent who recently was deceased. And then he gets a divorce. Mm-hmm. What's to prevent that money that came from his parent to go from their soon-to-be ex-spouse? He or she. I don't want to... It could be anyone.
Well,
I mean,
yeah,
then it can get messy, right?
It can. In family court, so you take the look at the length of the marriage, you take a look at that $500,000, and you say, was it segregated, right? Can we segregate it? So in other words, did they go on vacation? Did they spend some of that money together, right? So clearly the money's been spent, and it was spent on the marriage. What kind of debt did the couple have? Oftentimes you can, in divorce court, you can segregate an inheritance, but not always. So if it's let's say it was the woman who is going to have primary custody of the children, right? Mm-hmm. And she's looking for child support. Perhaps she or he is looking for alimony. And the court is going to say, well, you don't need this because you have a significant assets of your own that can assist and support you. Mm-hmm. So it would impact alimony. It could doesn't really impact child support because child support is a separate calculation, but it could impact the division of assets. We do in our documents, particularly, we have circumstances when an executor or a trustee can, if there is a pending divorce, not make a distribution to the beneficiary until the divorce is final, to the extent that it could impact the divorce settlement or the proceedings. So yeah.
In talking about these marriages, second marriages even, what are some of the potential minefields that people need to be aware of?
Oh, well, one of the things that you had talked about is, in the event of divorce, so Ned was talking about the divorce and what our law provides so that the will isn't going to be valid. And I think I had mentioned that jointly owned property and right of survivorship is no longer held in survivorship. But if you don't also change the beneficiary on your 401k, if you don't also change the beneficiary, you have to specifically make the beneficiary change on life insurance. And so a huge minefield in a second marriage is, did you put your financial affairs in order when you got divorced? And that applies to both spouses, right? Because I've had estates where the husband has failed to change the beneficiary on the life insurance, failed to change the beneficiary on the 401k. Those tend to be people's biggest assets, right? So people tend to have a lot of life insurance and tend to have a lot of money put aside in their 401k. His former wife was still the beneficiary on those two assets, and his current wife, with whom he had a child, did not get those assets. So it's a huge minefield. You got to make sure your financial affairs are in order.
Yeah.
If you both have kids, who's going to get what? If you have a kid together. So I come into a marriage with my kids and Ed comes into the marriage with his kids. Together we have a kid. Who's going to get what? Do we, the child is generally, in the second marriage, usually we have older children who we've educated, who we've done lots of things for already. So the younger child, the child that's ours, we want to make sure that there's enough money to make sure that kid can go to school, to make sure that that kid gets braces, to make sure, all those other things. So how are you going to handle that? So it's so touchy, right? Because you worked really hard for your money and you want your children to get something. I worked really hard for mine and I want my kids to get something, but we still want to take care of each other.
What about
right?
prenups? How does that factor into this?
Oh,
just hearing that, I take it it's
those are really important documents, right? But no one wants to talk about it. No one wants to do it. Ned and I have seen couples like practically on the eve of marriage say, "Oh my God, we have to have a prenup right away." That is absolutely the wrong time to do it. If you want to,
the night before you're getting married.
If you want to start, I did have that. I had someone the day before they signed the day before the wedding. And it was awful. They got to say that the marriage didn't last. It did not matter. It did not. But it creates, because there can be such resentment. There's such emotion tied into it. If there's one person who tends to have more money, right? So prenups can protect both spouses because it's like saying, well, what's mine, I get to keep. What's yours, you get to keep. And it can also address what happens to the ours, money that, things that we've created together. But oftentimes prenups are perceived because there was one person who has more money and the other person doesn't. And for the person who doesn't, who we are assuming is marrying you for love and not for money, right? And there's a huge amount of resentment, like, well, what do you mean you're not going to take care of me? What do you mean that you're not going to let me have anything? And you want me to sign this the day before we get married? Kind of thing. So prenups are great documents as long as both couples start long enough ahead of time and are really honest and open with each other about, hey, what do we want to do?
Where does a will and life insurance intersect?
Well, the interesting thing about wills, and we've talked about this in past shows, is that a will only controls those assets that are probate assets.
Okay.
And a probate asset is an asset that's solely owned with no beneficiary designation. So the thing about life insurance is that as long as the person who is named as the beneficiary is living at the date of death of the person whose life was being insured, then they have the legal authority to go directly to the life insurance company to make their claim. And so there's no need for a will or an executor or the probate court to get involved. So it typically, life insurance passes outside of the will. And that is, when we talk about estate planning, something that we always need to make sure that our clients understand, especially if the idea is that their children are young. And most, when you have a married couple, life insurance policy usually says this: the beneficiary is my spouse, the primary beneficiary is my spouse, and my children are the contingent beneficiaries, which means if my spouse predeceases me, the life insurance goes to my children. Well, most parents want to make sure that if their children are under the age or ages that they want them to have full access to funds, like, for example, a life insurance policy, $500,000, do you really want an 18-year-old, getting $500,000 dumped on their laps? And so what we often do for clients is create trusts, or at least that a trust would be created at the death of the children, at the death of the person under their will or revocable living trust, that the document says that if my child is under this age or these ages when I pass away, then I want those funds to go into trust. If that life insurance policy, the contingent beneficiary, isn't changed to name that trust as the beneficiary, then it goes directly to the children, and then they get it at age 18 typically.
So I wanted to talk about life insurance because I actually had a really interesting case in terms of a divorce. Okay, so the mother and father divorced. They have a child. The divorce decree required him to have life insurance policy for the benefit of the minor child. Okay, which is pretty typical because it's oftentimes there to support if someone dies and you want to be able to continue to have child support for the kid. So in family court, oftentimes if there's life insurance, we want to continue to make sure that both parents maintain their life insurance for the benefit of their child. I had a case where the father changed the beneficiary to another his sister, and I ended up representing he died. I represented the child. I had to come to court with the divorce decree and say he just violated the divorce decree because he was supposed to have this policy for the benefit of his son. And I had to go into superior court. I was in probate court for the estate. I was in superior court for breach of contract action. And the sister paid off her mortgage with the proceeds with it. She bought artwork. She did all sorts of things with the money. The money was spent, in other words. And
oh boy.
Yeah, it was. We won, but we had to fight like hell for it.
But it's spent.
It was spent.
Where
she wanted to give us the artwork. I was like, that's okay. It's a beautiful oil. But no. And the family ended up coming up with the money to pay us back the policy that was required. And so, we were talking about second marriages and some of the pitfalls. If you have something that's in your divorce decree that says you have to do something like this life insurance, and Ned was talking about how life insurance oftentimes passes outside of the will. That's why I had to go to Superior Court, all right, for this. But you better make sure. So I always ask people when it comes to a second marriage, I'm like, all right, what does your divorce decree say? Because the last thing you want is the ex-spouse or your children or someone saying, that loser didn't even follow the divorce decree. And
But wouldn't their attorney ask them that question?
I have to tell you, I've encountered lots of people who do estate planning. Ned can attest to this too, who don't ask a lot of questions. They say, okay, you want to do a will? And what do you want? And
is that by design? Is that because they don't want to know, and what they don't ask, they don't want to know the answer? Or is it, I can't imagine it's not amateur hour out there.
It is amateur hour.
Oh. We don't want to disparage our
No.
Well, you're not mentioning anybody's name, though. Then,
even in general, we don't want to do
we
that.
don't.
Attorneys get a bad enough rep.
It's true. We do.
There are some attorneys who are generalists, right? I'll do divorce. I'll do criminal. I'll do personal injury. I'll do.
They don't have a specialty.
And I'll do your will.
Oh,
yeah.
Okay.
And so Marianne and I, we didn't. One of the reasons why we merged our practices was because we both felt strongly enough that the law is so complex now that we can't be generalists, that we are specializing. We happen to specialize in the same areas of the law, which are estate planning and probate typically. And we do real estate also. But so somebody who is only doing a will once a month or one every 2 months isn't.
They don't think like we do,
date, right?
They don't think the way we do. They don't think to ask those questions, right. And so I don't think it's by design. I think it's just by virtue of the fact that they don't have to deal with the issues like we have to deal with all the time, and therefore ask those questions. But I always do. I always ask about the divorce decree in part because I have to litigate these type of things, but in part because it's the right thing to do to make sure that you're not setting your clients up for a battle when they die. I mean, I think that's really important for us as planners.
Folks, you're listening to Legal Notes with Charter Oak Law, Ned Barron, and Mary Ann Sharon. I'm Gary Byron. I was thinking more about also what happens if you don't have a will. I understand it's got to go through probate. Okay,
yeah,
but how long and let's say you've got kids, and a spouse even. I know it's rather irresponsible, but I would imagine you've come up against this more often than not, sadly. Shouldn't be like that, but be that as it may. How long can one anticipate going through probate without having a will? And what gets decided there? Can children or a spouse petition probate court and say, or do they even need to? Will he, when probate eventually gets around to this particular case, and do they say, we're just giving everything to the spouse or everything to the children? How is it divvied up when there's nothing specific as a will would indicate?
Well, our statutes do provide for what we call an intestate estate. So that is an estate where there is no will, and so there's it's in our statutes. So it's set in stone, basically. Yeah. Now, an example such as a divorce. Let's say that the husband comes into the second marriage and he has children. The expectation, I think, for most people that get married, and I've talked to plenty of clients when they were doing their first wills, when I explained to them what would happen under certain circumstances, and they say, well, I thought my spouse would get everything.
Right, and that's not true.
And that most people think that. I'm married, everything goes to my spouse if I don't have a will. And that's not always the case. And so in the example of if there's a divorce, the husband has children from a prior marriage, in that case, his surviving second spouse is going to get 50% of the estate, and his children are going to get the other 50%. So where he was thinking, well, my second spouse is going to get everything, that's not the case.
So let's say in that same example, he's the one who owned the house. He gets remarried. Wife moves in with him.
Yeah.
Right?
Oh.
So he dies. So now she's living in a house where she only now owns 50% of it. And the children who don't like her
own the other 50%.
own the other 50%. And maybe his will gave all of the personal belongings to the children. And so they come in, and we have seen this.
Well, he didn't have a will in this case.
Oh, okay. So we did. Right. Oh, thank you. Right. So, but now personal belongings, they're like, you know what? That was my father's before he married you. And I have had circumstances where people have called me, and the children are in there with a moving truck ready to take everything out.
Taking 50% of the furniture, 50%
of
the dishes, 50% of the pots and pans.
And saying, by the way, unless you can buy us out, we want to force the sale of the house. So, yeah, because
they own 50% of the house.
Because they will eventually. And how long, you did ask how long that process takes. Yeah. So it doesn't happen immediately. There is a process by which claims have to come in. And usually, I want to say rule of thumb is about a year.
Right.
Wow.
Whether you have a will or you don't have a will, probate typically takes a year.
And the children collectively get 50%. So if there's
that's in that hypothetical that you gave us, yes.
Right. So if there's 4 children, it's 4 children divvying up the 50%.
Yes.
Okay. I think I wanted to clarify that as well. Mm-hmm. We gotta wrap things up here, but I want to once again reiterate, if someone has a question that they would like to have asked on this show, on these very airwaves, hey, could even be next week. It's very easy to do. Simply email legalnotes@charteroaklaw.com. Once again, legalnotes@charteroaklaw.com. We'd love to get your question answered. And also, if you'd like to get more information, I always tell people, start with the website. Oh boy, you can learn a lot there. Maybe it'll answer your question. And if not, maybe it'll spark some others. www.charteroaklaw.com. Again, charteroaklaw.com. And to make an appointment, it can be done virtually. Danbury and Norwalk, they've got offices, but I know in Bloomfield, you also have offices more centrally located. Yep. It's easy to do. Just give them a call at 860-570-1229. Once again, 860-570-1229. For Ned Barron and Mary Ann Sharon, Charter Oak Law, I'm Gary Byron. Thank you so much for listening. Until next Saturday, have a good one, everybody. So long.